A very good evening to each one of you present here. This program, as we can already see, has gained its momentum, and here we are in the third day of our 2-week-long international refresher course. I am Dr. Manoshi Chakraborty, and I day. Now, I request you all to kindly keep your microphones on mute during any talk. If you have any questions or queries, kindly write them down in the chat section of the Microsoft Teams platform. At the end of the lecture, if the speaker so wishes, he or she will answer your questions and initiate an interaction. We have two esteemed speakers with us today, and the very first lecture, I'm very happy to announce this, is Innovation through Design and Opportunities for Industries, Need for Protection and Procedure for Registration of Design by Dr. S.K. Mitro, formerly Deputy Controller of Patents, India. Dr. Sushil Kumar Mitro is a Director, Center for Intellectual Property Rights, Adamas University, Kolkata. He has more than 36 years of professional experience at Central Drugs Laboratory, Ministry of Health and Family Welfare. I am Dr. Patent Office, Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, and as well as teaching experience at RGNIIPPA, DIPP, Government of India, Nagpur, IIT Kharagpur, NUJS Kolkata, NIPER Kolkata, and others. Dr. Mitro specializes in chemistry of synthetic and naturally occurring bioactive compounds, analysis of modern drugs and their formulation, intellectual property rights, patent system and their usefulness to scientific communities. Dr. Mitro has published several research and technical papers and chapters in books. He is also a member of editorial board of the reputed journal Frontiers Review. Further, Dr. Mitro is also fellow of Institution of Chemists for research work, particularly on marine toxins, specialized field in marine science, and also fellow of West Bengal Academy of Science and Technology for popularizing patent, a highly techno-legal subject, understanding of which is beneficial to the country for its economic growth of the people. Dr. Mitro visited WIPO Geneva, Switzerland in 1998, EPO The Hague, Netherlands in 2003, and EPO Vienna, Austria in 2015 as a trainee and country representative from Intellectual Property Office of India. We feel very fortunate to have you with us, sir. Over to you, Dr. Mitro. And kindly let me add here, I have been a student of chemistry all my life, so I'm very eagerly looking forward to your lecture, sir. Over to you. Thank you.
Thank you, madam. Thank you, Dr. Singh and Vice Chancellor of the University for giving opportunity to say something about our design registration procedure, value of design registration, particularly to the micro, small and medium enterprise, and also the fate of industry. Everybody is thinking depends upon innovation, that is patent. But design also is playing a key role for promoting the product in the market. So before going to my presentations, I want to share my presentations, and it is elaborate presentation, so please be patient with me, and thereafter I will reply all your questions. If you have in mind, then you please note it down and I will discuss it. Okay? So,
right.
desktop.
Sir, you may start sharing your screen.
Yes, I am sharing my screen.
Yes, we can see the title slide, sir. Now you may go to the slideshow mode.
I am going to the open share tray. First, it is coming in the desktop.
Desktop. Please select desktop.
Yes, I think it is okay now.
It is loading.
It is okay.
Yes,
Okay.
Yes, it is perfectly on.
Okay.
Yes.
I am very much sorry for that I am not very much competent enough
No,
to
sir.
do this thing because
These
the
things, these are
virtual mode
just
now we are
technicalities. We
learning.
all need
Still we are
to.
learning.
No,
So thank you, ma'am, for helping
no.
me.
Thank you.
So now I am going to start. So innovation through design and opportunities for industries. Why I am giving and selecting this title? This first I want to explain that everybody is thinking innovation means it will be a new product or a new process having technical benefits over the prior product, as well as it will give some market potentiality to capture the domestic and global market. But side by side, from it is not a new idea or a new intellectual property in our arena, because whenever our patent system develops in 1856, and thereafter a lot of development we have witnessed, and ultimately our comprehensive patent and design come to effect from 1911 after rules in 1912. But 1911, when our Patent Act was framed and Design Act was framed, at that time, India was under British rule. For that, our law was based on the UK Act and both patent and designs. But after independence, whenever we are going to frame our new patent law, because our first Prime Minister, Pandit Jawaharlal Nehru, has thought that this patent law will not sufficient enough for our industrial development. Then they have separated the patent law, and 1970 Act has come into effect from 1972. And thereafter, a lot of amendment was made. I will not go in details. The person who will be in the patent system of India deliver the lecture, they will explain all the things. But the design law, that 1911 Act, continues still 2000 because the design law has not got any importance at the time when the patent law has been amended after setting up lot of committees, Iyengar committees, texture committees, joint parliamentary committees, but they have not failed to amend the design law at that time. But whenever 2000, 1995, we have joined the TRIPS agreement, there was a part of design in TRIPS agreement that you have to modify your design law to address some of the issues reflected in TRIPS agreement. For that, we have changed our laws in 2000, and that was effective after 20th May 2001. So for that, why we are requiring the design law to amend after TRIPS agreement? So the need for protection for and registration of design is also very much required. How can it be done? So before going to that, just to recap, what is the difference between the major four intellectual property laws? Patent relates to the technological involvement, technological development, and that right is given for 20 years, and civil remedy is only available if there is a case of infringement of the innovations which is covered under patent. Trademark protects the brand goodwill that can be protected under Trademark Act. Here, Sony, the trademark, can be protected by Trademark Act. And the remote control mechanism of the television is protected under patent. And in every product, whenever you are selling the product in the market, always a product manual is required. Whether it is television, washing machine, or the pharmaceutical product. So that manual, the product manual, that is a expression of the product. That can be protected under Copyright Act. But another important intellectual property is the aesthetic beauty of the product. Whenever a customer is going to the market and purchase the product, they are not fascinated only with the brand or the manual or the technology. They are always selecting the aesthetic beauty of the product. And that external shape and configuration of the product is protected under industrial designs. And that right is given for 15 years, 10 initially, and 5 years after that you can renew it, and total 15 years right you can obtain. So in both and patent and design, you are got the civil remedy, criminal remedies available. But in copyright infringement or trademark infringement, you can have the both civil and criminal remedy. Now I am coming to the importance of design. It makes a product attractive and appealing to the customer side and may even be its unique selling point. Because when a person is going to the market to buy a television or a washing machine, they are not very much familiar with the technology playing inside the television or the washing machine. They will see first the attractiveness of the product, which is appealing to the customer side. Customer, which customer? The end user. An industrial design adds value to the product. That is over the product, which is made with the base of the technology. And there is a fair return of investment, and it is a business asset. And the more successful a design, the more higher it is value of the company. And only by seeing a product or aesthetic beauty, you can understand which the product which is coming from a multinational companies or a generic industries or small industries or like that. And it brings a fair competition in the market. Now, I'm going to just 20 years down the line. During the last century, if you see the attitude and the principles of the company manufacturers, that they are competing always the price. If I can keep my product price low, then it will go to the wide range of the customer and my product will be sold more. But today, we are thinking about quality, not only the price. If 2 rupees or 3 rupees or 5 rupees or 100 rupees will be more than I can pay, but I want a quality product. And tomorrow, because of our changing of lifestyle, we are now going for design. For that, we are purchasing more than 20 garments, bed sheet, our pillow cover, and all the things. We are changing mobiles, spectacles. I'm coming to example. Why we are buying more and more in spite of having that product is in my room. Because I want the new design because it is a lifestyle product which is creating a mind that, yes, I am enjoying it after buying and using those things. So design is the tool which will dictate the future market of the world. So I am coming to the another very interesting mark. It is quoted that in magazines that when companies are competing at equal price, technology is same, then functionalities are same, that the output is same, applicability is same, design is the only differential. Then if I go to buy a product, then I will see first whether this product has some aesthetic beauty or not. Because technology is same. So there is a beauty of the product, so I will purchase that product. Because functionality is same. So, and price is also almost same. Why I will not go better design? And next, I am coming to the design power. This is a subject I have taken from a PhD thesis of the Michael Henry, that if we put a small amount of innovations, time, money, and skill, 5%, we will get 70% out of return in the product perspective. The material value, labor, overhead, if we cost, then it will be reduced. Because there are large competitions in the market, for that material cost, labor cost, and overhead cost is going to reduce. But if we get a good design and apply to the design on the article, you can have a good return of the product from the product. So the design 5% investment in the product, initial product, you can have the return of the 70%. So design is the unique point of selling at the time to the end user whenever they're selecting any product. So now I'm going to the sharing of design of the selected countries. If you look at the sharing, USA, Europe, Japan, Australia, Canada, all are developed countries. But they are not paying much for the development of their design. Who are paying more emphasis? Korea, 16%. Japan, 21%. China, 13%. USA contribution is only 8%, and Indian contribution is. So you see that major of the companies, UK 5%, Austria 3%, Germany, the biggest technology development company, particularly the heavy engineering and the heavy chemicals, their investment is only 5%. So if you look at this situation, that the Korea, Japan, China is paying more attention to the design, and Indian contribution is only 2%. Why registration of design is required? Because to protect a new and original design applied to any article, which is the creation of a human intellect, registration is must. Because if you don't go for registration, it will not create a product. Without registration, a property cannot be created. So property, whenever you are going to create, always you have to register it by the design law. And to prevent imitation, commercial exploitation of the innovator's design without prior consent, you can have the protection of your design. And also, it is a reward theory like a patent. And to obtain a reward by commercial exploiting the design, as well as you can assign it, you can license it to other parties, and you can earn the royalty or the profit out of that new design. Here you know that the National Institute of Design, Ahmedabad, is going to develop different kinds of designs applied to different articles. So already there is a dedicated institutions in India, and a lot of other industries is also going to develop design to create market leadership also. Now, if we look at the global trends, as because it is an international forum, international research course, I must say something about the global trends also. So in Japan, you see the implementing awards of good design selection system in 1957. Then 30,000 products received GMA, good design mark. In Singapore, offers incentives to greater design activities in industries. And if you go to the United Kingdom, set up Design Council of UK to use design as policy and strategy for education and industry. So in education and industry also, the design council they have set up, and around 10,000 student designers graduate each year from the UK. So only they are creating new design. And South Africa encourage employment for industrial designers and promote design among manufacturers, schools, and general public by means of exhibitions in open forum. So industrial design award scheme also they are promoting for the high standard of design. If we go to the Malaysia encouraging the local designers to create new design. Now, but in India, if I say design is in general context, design is a peripheral activity here. We are paying more time, money, and skill for innovation, for developing product and process, not giving proper attention to create new design. Always we are trying reverse engineering. Already something is there. We are changing and modifying something and create a new design. And always we have seen in my job at the time that technology interpreted as design. Because in major area, the technology that is the functional part is interpreted as designs. I will come in examples, particularly in toothbrush case. I will show, and failure to create brands and to lead. Because design also can create a brand. Whenever you are delivering a product through a container, and if that container is a very attractive shape and configuration, that from that attractive shape and configuration, that company creates a brand that this is the product from the Novartis company, or this is the product from the Bichaman Group company or Tata company. So the design also can create brand like a trademark also. So there is a close overlapping area of the design and trademark overlapping area, particularly whenever some court cases are going on in respect of the trade dress. Trade dress infringement. So I'm coming to the Indian Design Council. India also has thought of that we have to make a new design policy. For that, the national design policy already approved by government in 8 February 2007. And design awareness, design promotion, design development, and positioning India as a top design destination and Indian design mark, IMARC certification, all the things we are going to promote through DIPP, that is Department of Industrial Policy and Promotion through Ministry of Commerce and Industry. And for that, we are now getting more and more application for registration of design in design office. Now, if we look at the application side, what is the application of design in our daily life product? If we go to the small scale industries product, MSME products, shoe, chappal, pen, textile goods, carpet, wall clock, ceramic tiles, plumbing equipment, sanitary goods, so and so, casserole, water bottle. Water bottle, every day we are taking the mineral water, and you never find two bottles are of same design in the market. And bag, suitcase, flower vase, ashtray, toothbrush, and lot of application of design is coming in toothbrush, toy, fan, and textile garments also. And in large scale product also, if we consider then washing machine, refrigerator, television, computer, AC machine, this to all are the big companies product, grinder, vacuum cleaner, all are coming also under the design registration process. Now you see the consumer product. This is the daily life product. We are using all the things to see how beautiful and how the aesthetic value has been created in that product. Now if we go to the pharmaceutical product, pharmaceutical industries mean for pharmaceutical product, for the treatment of the patient. But when they are going to deliver that product through packaging materials, through container, through ampoule, through syringe, through capsule, also they are going to take the help of the aesthetic beauty of the design applied to that product, applied to the delivery material, so that any customer can get the idea what is the value of the company and how the design power they are using to create market leadership and create the brand also. Now the textile, another area. We are always changing our daily life product, the bed sheet, curtain, sofa cover, and others. Why? Because it is not that the previous product is not to be used. So we are changing because of the lifestyle. We are creating new lifestyle. So because we want the aesthetic of our room, aesthetic product. Jewelry and another article. Now the girls and ladies are not using the gold ornaments. They are using the different jewelries of metals, stones, and other materials also. So you see how the design is capturing slowly on the textile and jewelry products also. Not only the daily life product. If we look at the farm machineries, the big products, agricultural equipments, you see all the products are coming in our office for registration design, because it is the primary registration of design of the product will give you one intellectual right. Functional part, you can go for protection for patent. But the aesthetic beauty, if you can create and can register, then that will be another intellectual property for you to create the brand that this is the product manufactured by that company. So I am coming to the design filings. Statistics. If we look at the statistics, 2015 to 2020, the filing almost 10,000 to range it is. But just 2021, when the government has created certain policy for the design, registration, and the awareness, particularly for the micro, small, and medium enterprise and other companies. So you see, already I have got the information that within 6 months, 5 months to 6 months of this financial year, we have received 10,000. And we are expecting 18,000 applications in this financial year. Registration also is very good. 80% applications is registered. In case of patent, major applications are rejected or refused or abandoned or withdrawn. Hardly 15% applications are granted. But in design, the opportunity is that to get the registration, because 80% applications, very easily you can register it. And only time period is 6 months. Within 6 months, you can register your design and can create one intellectual property for your company. Now, we need times like 2000. Already I mentioned the 1911 Act continues up to 2000. But Patent Act created 1970 after independence. But when we have gone to change that our Design Act, when the considerable progress in field of science and technology, efficient legal system for protection of industrial design to ensure unnecessary extension of protection of design activities and promote design activities and compliance of TRIPS. So that means the TRIPS has forced us to amend the design and access to the Paris Convention. So Design Act, when has come into effect, that law is saying that design office was only in Kolkata. And all prosecution is also going in design office from Kolkata. It is the design wing of the patent office. The patent office, there is a design wing. But government has created the facilities of filing application for registration of design in other office also, Madras of Chennai office, Bombay office, Delhi office, but that will be transferred to Kolkata office for the prosecution, request for extension of copyrights, petition for cancellation of designs, and rectification of register of design. These four areas of work for registration, extension, cancellation, and rectification also can be filed in the branch office, Delhi, Bombay, Chennai, but that will be referred to the Kolkata office for final decision from the head office, Calcutta. Now, what is the requirements for registration of design? The filing should be made in PESCI form. I will show you the form, and PESCI fees are there. Previously, we have three categories of fees was there: the individual fees, natural person, MSME fees, and also we have another fees for the other than MSME, that is the big companies. Now we have two set of fees. One is the big industries fees and MSME sector and the natural person combined, coupled with each other, and we have two fees system: 1,000 for the natural person and MSME, and 4,000 application fees for the big industries. We have to submit the 4 copies. Statement of novelty and disclaimer statement is given. I will show you how it can be done, and power of authority. And processing of applications is generally made within 6 months from the date of application of design, and thereafter it will be notified in the Patent Office Journal after registration and entered into the Register of Design. So this is the Form 1. Then the Form 1, design is registered under different classes. And we have 32 classes under local no classification, like trademark. Trademark is also registered under different class. Here design is also registered under different class. So whenever you apply for a registration, you have to mention for the purpose of the use of the product. Because one product can be used for 2 purposes. So if it is used for 2 purposes, you have to register in 2 different classes. Otherwise, your protection will be limited only in 1 class. So class number, photographies, applicant name, a country, priority countries, and everything you have to fill up. And generally, attorneys are taking care for that. Now, this is the representation sheet. Just like a patent, we are to submit along with the form a patent specification, provisional specification or complete specification. Here also we have to submit one representation sheet. If the representation sheet 3-4 sheets, then total seat number, name of the applicant, and the perspective view. Use a sheet is a teapot. And whenever you are applying, you have to explain what is the novelty of your product. So here you see the applicant is saying the novelty resides in the shape and configuration of the teapot, but no functional part will be registered. So they have given one disclaimer part. No claim is made by virtue of registration in respect of mechanical and other actions. And also trademark, letters, words, numerals appearing in the design, also you cannot claim for that. So there are 2 parts. One part is the novelty part, and other part is the disclaimer part, that we are not going for protections for any kind of mechanical or functional part, as well as the trademark letters, numeral appearing in the representations, and thereafter signature. Now, if I go to the a simple flowchart, you may find that it is a very complicated process. No, at all. Whenever you apply, one 6-digit number will be allotted. And if that product has the multiple function, multiple purpose, then it will be, say, for 3 ways you can use that product. Then 001, 002, 003. In one number, you will get the 3, 1, 2, 3. It can be used for 8 purpose, then 1, 2, 3, 4, 5, 6, 7, 8. So number will be given by the office, and thereafter this will be referred to the examiner for examination. After examination, an examination report will be given to the applicant, and applicant will meet the objections within 6 months from the date of filing, not from date of examination report, mind you. But in patent, the time period is given from the issue of FER. But here, within 6 months, you have to complete the requirements. And if it is satisfied, it will be registered immediately. If it is not satisfied, the controller will offer hearing. And based on the hearing, the matter will be settled, whether it will be registered or refused. And whenever it will be registered, it will be published in the Patent Office Journal and entered into the Register of Design. Okay? Now I'm coming to the role of examiner. What is the role of examiner? In the 1911 Act, there was no provision for role of examiner. But this new provision has been introduced in the new Act because it is the role of examiner to assist the applicants to gain the best registration protection for their design within the meaning of the Design Act. Because examiner is the guardian. So examiner has to check whether the article of design registration passes the section 2A, 2D, section 4. I will come in detail what is section 2A, 2D, section 4 and section 5, and sometimes section 6 also he has to check, and the classification they will check, and thereafter exhaustive search is made whether the prior registration of design or similar products are already in the market or not, and formality check, and they went for registration and controller will register it. Now what is section 2A? You see, our law, design law is something different from the law of other countries. Fine. Why I am telling? Because always we are saying, whenever you are applying a design, what is design? Design is a feature. So that feature, whenever you apply to the article, only that will be subject matter for registration of design. But if your product is not applied to an article, say for icon or a pattern, then it will not be subject matter. But when that pattern will be applied to a tie or a garments, then it will be coming under classification of textiles, 0501. Whenever your icon, it is not an article. I cannot buy an icon from the market. So that icon, when applied to an article, say for a bottle or a knife or for any article, then only it will be subject matter. So the article is defined under section 2A that design should be applied on the article. And the article means the article of manufacture. It will be produced by industrial process or in substance artificially or partial artificially, partly natural, and it will be sold in the market separately. Say for example, I am giving example of a bottle. Bottle has two parts, bottom part and the cork, PP cap. So if the bottle is sold in the market with cap, then it will be registered. One registration will be there. If the bottle is, bottom part is sold separately and cap is sold separately, that means there are two parts. It is manufactured and sold separately. Then it can be, though it is not a complete article, but as because it is manufactured and sold separately, you can have the two registrations. For one part, bottom part, that is the bottle part, the container where the liquid will be stored, a substance will be stored, and the cap part. So article, you must keep in mind that here there is an overlapping area of the copyright also. Section 15 of the Copyright Act says that if you create a design and produce more than 50 copies, then your copyright will be seized. Then only you will get the protection of the industrial design registration. So copyright is giving a limitation that more than 50 copies if anyone produced, then their copyright will be seized. So that person has to register that product under Design Act. But in copyright, there is no question of novelty. But in design, you have to satisfy the novelty, new and original of the design. So the article includes an article of manufacture, any part of the article made and sold separately, or a set of the article. Say tea set, coffee set, sherbet set. It is sold in the market as a set, not separately. So it can be registered under single applications also. So now I'm coming to the article of manufacture. What do you mean by manufacture? Because it will be produced in a large scale. So the word article of manufacture is not defined in the act, but have a very wide meaning and would include man-made articles, whether made by machine or by hand. The word manufacture used in this context conveys the meaning that the article to which the design is applied are mass-scale production by the industrial process and manufacturing. And this applies to a wide range of articles, which would include the article and which could be the consumed, such as the breakwares, items of foods, as well as more other durables. That means that for it is called the industrial design. Now I'm coming to a set. What is set? Set means a number of articles of the same general character, ordinarily sold together and intended to be used together. So set of articles can be a set of articles. Each article in the set or both are set articles or a group of articles, all are coming under set. And these are ordinarily sold or intended to be used together and commonly designed and same general character. And this is an example, you the set. This is a tea set or coffee set, whatever you can say. Set means a number of articles of the same general character, ordinarily sold together and intended to. So if in this case, no need for going for filing different applications for different articles. Only by a single application, you can register total set. There may be multiple articles are there, but it is of general character. So now part of the article already I have told you, the bottle and cap. So if it is manufactured and sold separately, then it can be registered by two different applications. Otherwise, it will be in one application. Now I'm coming to the definition. Section 2D. What do you mean by design? Each design never refers the plan, building design, architectural design, or the any layout design. This design means the features of shape and configuration, pattern, ornament, composition of lines, colors, applied to an article, either in two-dimensional, it is in the cloth or a paper, or in a three-dimensional. It may be by a manual process or mechanical, chemical, separate or combined, which in the finished article, how it can be judged for registration, appeal to eye and judged solely by eye. That means eye is the sole judge for taking decision whether it is a registerable subject matter, but does not include any mode principle. That means the functional part that can be protected only by patent or by design. That should not contain any trademark or a property mark, and artistic work as defined in clause under Copyright Act, the section 2 of the Copyright Act. So the Indian Rail, Air India, these are the property marks that cannot be registered under design. So under the definition as provided, there are several elements of the definition of design. Mode of principle and construction. Already I have told you that mode and principle and construction, the design applies, but should not essentially consist of mode of principle and construction. There is a very good case. In 1999, Scott Construction versus Action Construction, the court said, the primary object of the act, the design act, is to protect shape and not the function or the functional shape. So the expression of the design does not include a method or principle of construction of the features of shape or configuration, which is dictated solely by function, which the article to be made in the shape and configuration has to perform. So if there is any functional part, that can be protected by a patent, not by a design. So mere mechanical device, in another case, Beecham Group of Anchor Health, in the court has given a verdict in 2004 that the design on toothbrush, what is that? The examiner has to check the following parameter, a mere mechanical device or not. If it is a mere mechanical device, the contrivance is not a registerable subject matter. So in this case, the court has said The design patent we design as a toothbrush, and the purported novelty reside in a zigzag bend of the toothbrush. And the court was of the view that zigzag bend was the functional part and had even obtained a patent on the ground that a zigzag bend introduces mere flexibility in the toothbrush. So by merely putting rubber cushion in the gaps, and this part does not become a design so as to preclude the others from using it. These rubber cushions may enhance the flexibility, and introduction of certain patches thereon does not introduce any design therein. So it is a subject matter for patent, not for registration of design. What I say. So mere mechanical device, a lot of other cases are there. I'm not going into detail, but just mechanical function cannot be protected under design if that function is solely dictated by this design. So design, another important word is original. Whether this design is original, new and original. So word original has been defined under section 2 of Design Act. What do you mean by originality? Original in relation to design means obtaining the author of such design and includes the cases which, though old in themselves, yet are new in application. What does it mean? I'm coming with an example. See, that I'm actually, say, for example, Qutub Minar. Qutub Minar, design of the Qutub Minar is known to everybody. So anyone can make an ashtray with the Qutub Minar design or a showpiece of Qutub Minars and can keep it on the decks or the reading table. So though the Qutub Minar design is very much known, but the application of the particular Qutub Minar design, a Charminar design tower, a Taj Mahal, be applied in any article as a showpiece, that can be registered under the Design Act. And there are certain prohibition in registration of design. Section 4 of the Design Act is saying that if it is not new original, if it is disclosed publicly for application, if it is not significantly distinguishable from known designs, and if it contains any scandalous matter or obscene matter, it cannot be registered. So section 4 is very clear. That means your design should pass the test of new and originality, and should we disclose any exhibitions or any part of the world, because we are considering global novelty, and also no scandalous matter and should be significantly different. Now the criteria for design registration, how we are determining the novelty and originality. New and originality means that it has been invented or created first time, and it has not been reproduced by anyone before these applications. And novelty can even reside in the application of a known shape or pattern, new subject matter. I am already given the example of cigarette holder made in the known shape of Qutub Minar can be registered. Though Qutub Minar is known to everybody, but nobody has applied this design feature to a cigarette holder. So novelty or originality is in the eye of the arbiter and can be judged by the experts in the trade. An expert who is aware of the common trade knowledge and uses in the class of goods to which the design is applied would be the one entitled to pass the verdict of the novelty. Now, application to a particular article. The essential component for registration is that the design should be applied or be applicable to any article by industrial process. So it must be incorporated in the article itself so as to form an apparent integral part of the article, and maybe to leave shape of perfume bottle or a configuration. Three-dimensional decorative designs made in a bed sheet or a wallpaper or in two-dimensional. Thus, mere design of industrial plans, layouts, installations are not registerable subject matter. But design feature should be identified, and it may be applied to the two-dimensional, three-dimensional. That is the article, it can be registered only. So no prior publications. I am not going into detail, but the major thing is that before any kind of filing, don't go for publication. Like patent, you have to first file the application and then go for publications. Then you can use it. I have seen many cases, the companies are coming for filing registration of design after putting their product in the Amazon site. How then Amazon site is public site? So if we put the product there and thereafter coming to for registration, your application will be anticipated by that disclosure. So it will be considered as a prior publication. So it should not be done. And also, private or the secret use or the experimental use of design will not constitute a publication by prior use. That is also design a model for the purpose of my design and product, and then I can go, and it is privately and secretly if you use, then I will not consider it as a prior publication. But whenever you put the product in the market or an open site, there is no restrictions, then it will be considered as a publication. And the visual appeal. This is very subjective in nature because I have worked both in patent and design. But I have seen in patent you can take decision based on the paper document. But how will I can judge whether it appeals to I or not? In my eye, it is appeal. But in the eye of Professor Rakesh Singh, it is not applicable. So a product can be registered, cannot be registered, because criteria is visual appeal. So the industrial design protection is considered solely with the protecting the appearance and not the functions of the article, like say the carved handle or toothbrush. The features of the design in the finished article should appeal to the eye. And this implies that the design must appear and should be visible in the finished article for which it is meant. And any design in the inside arrangement of the box, say jewelry box, money parts, or a refrigerator, inside cannot be registered because it is generally sold in the market in the closed state, may not be considered for registration. But if you want to take the registration of the inner part, you have to apply a separate application, the open condition, not the closed condition. So it all goes without saying that at this juncture, the design should not in any way to be obscene and offensive to public sensibilities and sentiments. Even a combination of previously known designs can be considered as long as the combination produces of the new visual appeal. But in that case, what to justify? Yes, it is better than the previous product. And color scheme can also form an important element, particular design, but cannot constitute the entire design itself. Say, for example, I have given a color combination. Different color combination for attractiveness. Then only is entitled for the color protections. That is the pattern, shape, not the shape and configuration, only the ornamental pattern, surface pattern, the station. So now I'm coming to the individual character. Individual character, the design should have an individual character. Because I am separate. Dr. S.K. Mitra is separate from Dr. Rakesh Singh. Individual character. So this requirement is made if the overall impression produced by the industrial designs on an informed user differs from the overall impression produced on such a user by any earlier design which has been made available to the public. In a very good case, I just heard Honorable Judge Vishwanath Samadar in Calcutta High Court has given. That two bottles are coming. I will show you. Two bottles are coming. Two bottles are very good shape and configuration and attractiveness is there. But not much difference is there. They are saying both the things are very applicable to eye. Both the things should get registration, but very significant difference is not there. For that, can I reject one application because of no significant difference is there? So it will be better for giving opportunity to the applicant for registration both, so then they can go to the market and get the competition. And if the problem is then they can go for cancellation. Why I will stop at the time of birth? I have to allow the birth, and thereafter, if punishment is required, then court will say, well, yes, one will be cancelled and another one will be staying in the market. So the individual character. So new and originality, lot of court cases are there. If I don't want to go in detail, Section 5.1, another section, by Section 5.1 we are giving the registration. The controller may on the application of any person claiming to the proprietor of a new and original design not previously published in any country country. That means it is a global novelty, and which is not contrary to public order and morality. No scandalous matter is there. Registered design under this Act, Section 5(1). And the controller shall, before such registration, refer this application to the examiner, and based on the recommendation of the examiner, controller is giving registrations to you. Okay? So now, classification. We are following Locarno classification. We have 32 classes. And under 32 classes, all the articles are classified under 32 classes, and subclasses are also there. So whenever you apply for a design registration, you have to apply under a certain class. If that product has multiple use, you have to apply 001, 002, 003. You have to mention the different use of the product also. Now, search. Search is very much required because examiner has to establish that it is new and original. So what are the similarities? Are the designs identical? This is the first question to the examiner. What are the difference between two designs? Is it obvious adaptation of previous design? Is it a combination of the old features, or it is the or what are the priority dates are involved? So you see, a lot of things are there where the examiner has to see whether your application is fit for registration or not. This is the search module. You can put here the class and the article name, and you can find lot of similar products. Then you have to check whether your product application is similar to the prior art any product or not. Now you see the handle. This is the door handle, or you can say the any almirah handle. You see whenever the application is there, the three different handles are coming. That means no handle is very much similar to each other. So three handles can be registered under that particular class. Just I am giving the example of the bottle. You see the instant design is this, and prior art design is this. You see almost same, but the next size is different, and the overlapping zone is there. But you see, there's a certain difference, but it almost looks same. This is the case of before the Honorable Judge Vishwanath Samadar, and he has allowed the two registrations also. He is saying, I will register two because and apparently it may be similar, but there are certain differences also there. So why I will allow that thing? So it is better for registration, and there are pretty many problems. Manufactured and sold there is a confusion before the customer. It can be registered the end user, because end user is the final person to decide. Now whether it can be accepted definition. So in that case, I will allow both registration by design. It will be decided by the public. This design never registration in cancellation process. So after registration, this patent certificate is issued by the design office. The patent design office is issued the this design means the features of shape and the design number, pattern, ornament, composition of lines, colors, name, applied to an article, and in the last dimension. And the last, you see, or the controller general signature is also 3 dimensions. So next, it may be by a manual process or mechanical, chemical separator combined, which in the finished article, Section 11, subsection 1 of Section 11 saying the design when registered and just registered proprietor. That means I is the sole judge for design, subject to provisions of the Act, whether it is a registered design. He can produce multiple but does not include any more design. And copyright functional parts that can be put on by patent or by design. Under the copyright, that should not copyright means trademark right to or a property mark and artistic work and defining clause. This is given initially 10 years and one term renewal, that is the 5 years term. They will get more after getting renewed up within the period of 10 years. That is total 10 plus 5, 15 years size. So examiners' objections generally is going to the applicant. The design prima facie appears to be identical to the registered design. And if there is any novel feature, so you have to pinpoint the novel part of the design. Where is the novelty? And for which you are getting protection, you want protections and monopoly right for that. And what is your opinion of the applicant in respect of that this objection, and design should be registered or not? That will be decided by the controller after getting the recommendations from the examiner. Now, if controller is not satisfied, the application will be refused. You can paper appeal before the High Court. And another important section we have included in Designs Act 2000, that if it is prejudicial to the interest of the security of India, if someone is making any design of submarine or some gun or some ballistic missiles, like that, then it will be coming under the secrecy provisions. So, like patent, it will not be registered, and refusal of registration of such designs will be made with the notification showing interest. So that means that it will not be notified also. So now the post-registration. After getting registration, we have two sections, D1 and D2. D1 section deals with the pre-registration and D2 section post-registration. Because after getting registration, when you are getting right, property right, then certain formalities and certain duties are there in the design wings. They have different sections are there. I'm not going into detail. The notification, prohibition of publication, inspection, request for information of design, restoration. If your design becomes seized because of not renewing, certain procedures we have to follow. And again, if you go for license agreement or the assignment of design to any company for production, then also you can do it. And if your design is copied by someone, that is a piracy, that is the infringement. But we are saying about the infringement of patent, the piracy of the registered design under Section 22, some penal clause is there and applicable provisions are also there. These are the different sections provided in after getting registration of your design. So notification, we are giving notification in Patent Office Journal, and registered design is published for public after getting registration. There is a publication. But in case of patent, before grant, the patent is published. But in case of design, only after registration it will be published. And under Rule 22, particulars of the registration of designs, registered design is published, and one or more best views of the representation will be published. You see, this is a chair, table, tools, containers, all are it is published. We are publishing 52 journals in every week. Friday we are publishing our patent and design matters about the activities of the patent filing, grant, registered design, and also the assignment, renewal of designs, everything we are publishing, and to know the public that what is the present legal status of the applications. And prohibition clause is some publication of design is there. If, say, for application is your abandonment. In case of patent, you are not getting any relief because already it is published 18 months. But in case of design, you will get relief because whenever it is not registered, it is abandoned or refused, your application will not be published. So it is not published and it will keep secret by the design office. And also, you can go for inspection of design. When it will be registered, then you can apply for inspection of design under Section 17 and see whether the design is very similar to your product or not, and you can go for cancellation proceeding, taking certified copy of that. So also you can go for search. Before going registration, you can apply under Section 18 of the Design Act and perform search, and the office will search your article and give the opinion whether it is anticipated by any prior publication or prior registration or not. So this is the advantage in Design Act, that before filing also you can have the idea about the new and originality of your application, which is absent in Patent Act. But in Design Act, there is a provision of going search, and office will go on search of your applications. Also, if you produce certain information under Section 18, the controller will give you the on that. Entry of the registered design is made under Section. So whenever it will be registered, if there is a register of design, now register of design is available e-register, and public can see from your desktop, the IP site, you can have the register of design. So it is reflected, all the registered designs are reflected in that register of design. And extension also you can do before 10 years. If you apply for extension, then you can get more 5 years extension time. And there will be the restoration provision. Previously, it was not there. Restoration provisions that if you apply, if your design is lapsed, you have forgotten to renew up within 10 years, then you can apply for restoration. And if it is restored, then you will obtain another 5 years time to enjoy that monopoly of right for using the design. And the condition for restoration is there, because if your design is seized and thereafter restored, between that period you will not get any piracy benefit or the infringement benefit of your design if someone is used your design. Because at that time I have inspected that register and seen that your design is seized, term is over, you have not filed the renewal. That means it is in public domain. So I have every right to produce it. But if it is restored afterwards, so between that period, from date of cessation to date of restoration, this 2 period is the product, if it is infringed by other, will not get any punishment because he is an innocent infringer. So in that case, that time period will get relief by the infringer and not giving any compensation for that. So entry in the registers, different class, notification, official number, change of proprietorship is there, everything is there. Inspection, and also it's possible you can go and take the extract of the register of designs under section 26. Power of controller, if some clerical error is there during entry of any document, controller has the power to correct that. Assignment, mortgage, license also you can go with your design for non-exclusive license or exclusive license you can do for making the product more and more available to the public. And thereafter cancellation. Because any registration is subject to cancellation, just like in patent also. Opposition proceedings are there in patent. Here cancellation proceedings. If someone is found that after registration, because before registration it is not coming in public domain, it is not published. So after registration only it is coming to public domain, after notification in Patent Office Journal. So whenever public will get the knowledge about any registered design, he may say this is the copy paste of my design. So I want to cancel it because otherwise my business volume will be reduced. So he can go to the controller and file a cancellation petitions and taking these grounds that the previously registered in India, published in India, not new original, not registrable design, or not a design under section 2B. And after the formalities and the procedure laid down under Rule 29.1, 29.2, when the matter will be complete, controller will offer hearing. And after hearing, the matter will be settled by the controller whether this design will continue in the register of design or it will be cancelled and removed from the register of design. So these are the things. I am not going in details. Already I have talked many things about the design. So now these appeal. Appeal is the provisions in every decisions. In design, if any controller is passed any order, refuse the design, or in cancellation proceedings, if order is passed against any party, then any one of the party, aggrieved party, can prefer appeal before the High Court. Appellate court is High Court. Here, this is the case of the High Court. Just I'm giving one case example here. that the Delhi, one appeal petition is filed before Delhi High Court. And Delhi High Court has given one order. But the aggrieved party has preferred appeal to the Apex Court, Supreme Court. And the Supreme Court in the SLP, Godrej versus Beckinsale Austria Private Limited, is saying that your appropriate court is Calcutta High Court because design wing of the patent office is in Calcutta. An order is passed from the Kolkata office. Your jurisdiction is Kolkata High Court. Why you are coming before Delhi High Court and get the order and coming before us? So the court held that we are of the view the imposed order of the Delhi High Court cannot be sustained, and we accordingly set aside the same and hold that in the instance case it is the Calcutta High Court which have the jurisdiction to entertain the appeal under Section 19 of the 2000 Act. So the proceedings before the Delhi High Court are therefore quashed, and the appellant is granted leave to move to Calcutta High Court against the order of cancellation of design on the grounds taken in those appeals, as well as such other grounds as he may think fit for the event for the purpose of deciding the questions of cancellation of the appellant's design by the controller of design Kolkata within 30 days from the date. So if the appeals are filed within the said period, the delay is taking such proceedings shall be. So you see, that means the appropriate jurisdiction is fixed for appellate court is only Calcutta High Court, not the other court of India. So if anyone agrees on any decision of the controller, either in registration or in cancellation proceeding or in rectification order or any restoration order, then only they can prefer appeal before the Calcutta High Court, not any High Court of any. So this is the order. The rectification is also possible. Controller, you can apply, anyone can apply before the controller of designs for rectification. And rectification of registered design is possible. And they have to file with Form 7 and fees also. And notice of oppositions, provisions is always there, rectification. You have to give the opportunity to the opposition before rectifications. And power of control already I have said. So now this is the most important slide. But because whenever you are buying any product from the market, you don't know whether it is registered design or it is pirated design or it is the design of others. I don't know. So it is advised by the office and the laws that Rule 26 is saying that before delivery on sale of any article to which registered design is applied, each article to be marked with registered, that is the RD, and also the registration number, except for textile goods and brittle articles, because you cannot punch on that. So whenever I am selling any bottle or toothbrush or knife or any bag or suitcase or anything, always I have to put the RD number, registered design number, so that any person can understand that this is the product registered under Design Act. So I will not copy it. If there is no mark, then any party produce that product and sell the market and will say before the controller, sir, I am innocent infringer, I don't know whether it is registered of design or not, I am not very much aware about that. So this may resist the potential infringement and help in the legal actions. So piracy is another important thing. If it is copied, in the term of Design Act, it is called piracy. In patent, it is called infringement. If unlawful use, sale, imitation, import, publish of any article belonging to that class of design has been registered shall be liable to a punishable offence. And fair damage is 25,000 and recoverable damage not more than 50,000. And relief on the suit or any other proceedings shall be in any court not below that. So infringement proceedings can be brought not below district court. If there is a counter claim, then only you can, that will be transferred to the High Court. Otherwise, that will be decided by the district court. And the lessons. What you have learned from my lecture, that the registration of design must. If you don't register the applicant, particularly the micro, small, medium vendors, they are producing a lot of products and selling the product in the market. And big houses purchasing their product and assemble and selling the product in the market. Big house is getting registration, but small house is not very much aware about the registration of design. They are not so much aware about that. So design not to be disclosed to the public prior to registration. Many persons is putting the product in the website, Amazon site, or any open site, and thereafter coming to my office and ask for registration. How can I give that? Already it is disclosed before filing this application. And it should not be published in India and not in other countries. You must keep in mind, our 1911 Act was the territorial novelty, but our 2000 Act is global novelty. We are looking for global novelty. We are conducting search for global novelty. So these three things always should be kept in mind, that registration of design is must to protect your design. This is your business tools. To get the market leadership, this will create a better option for selling your product. and design not to be disclosed to the public, prior registration, prior filing. If you don't get registration, at least you must go for filing this application, then you start using. At least get the date. And should not be published in India and not in other countries. Even you cannot export that product. So all these three things are the lessons to you for getting registration. Do the business with industrial design, right? You can take, and it is very easy to obtain. Within 6 months, you can get the registration. Fees are very nominal, and also you can have the right of 15 years. So with these things, I must say that good design is good business in 21st century. Thank you. Thank you everyone for patience.
Thank you so very much, sir, for your wonderful presentation. Now, we may take a few questions. I would like to request the participants to pose their questions for Dr. Mitra. You may kindly unmute yourself and pose your questions for Dr. Mitra.
Mr. Sarkar has come.
So in case we do not have any questions for Dr. Mitra, I would like to request Dr. Rakesh Kumar Singh for his concluding remarks.
Yeah. Thank you, madam.
I have a question. To Mitra. Sir, I was listening to your presentation, very nice and very informative. Sir, I have a question because we regularly get a lot of queries related to the design application. Sir, and the thing is even a day before yesterday, there was some other attorney who filed that application from Pune, and it is being objected by on the examination that they have given the citation of Flipkart and Amazon.
Yes.
And the design office, and they said this is there is no novelty in it, and because the publication is there. So, sir, this particular thing, whatever I felt after doing these kind of design applications, very few design makers, whether those who are manufacturing the product, they are not very much aware that whenever you go for registration of a design, the design particularly should be very, secret, so that you can, maintain your novelty. But if that's so, is there any procedure that we can take the steps to educate this kind of, the creator of the novel design? Because as it is published in a public domain, then the novelty doesn't come. And he said this particular product, it is only published by him only, but his design is now in question. So what is your suggestion?
And I understand your question. Nowadays, the patent of design office is normally going for search through Amazon or Flipkart. And previously it was not there. Only we are doing search in different design database available in different countries' website. Because we have created this search engine linked to the Amazon and the Flipkart, because every day they are floating different articles and different products in the market and showing to the customer and inspire customer to buy that product. But they don't know that without at least filing the application, if they do this thing, it will come as a prior public knowledge or prior, not a prior publication. It is not like a publication, but it is coming to prior public knowledge. Prior application, you have given your product knowledge to the public. So automatically, your own application You have done it, and your own application will be anticipated by your own display of your product. So for that, I have told that even in any exhibition, previously when Amazon was not there, Flipkart's provision was not there, always we are trying to say the people that don't put the product in exhibition also. Because if it is government-aided exhibition, then only you can have the time for 1 year time you can have to take the protections. It is in the patent law also the similar provisions are there on section 29. In the design law also the similar provision is there. If it is published in exhibition organized by the government with the permission from the controller, then you can file the application within 6 months from the date of exhibition of your product, because it is required to exhibit your product to the public, what is the function of the product, what is the beauty of the product, what is the aesthetic look of the product. So only in that case you will get the exhibition, but not in Amazon, not in Flipkart, not get any relaxation. Understand my point?
Yeah.
Because Amazon and Flipkart is not government organized exhibition. You are putting your product for the purpose of marketing, for the purpose of advertisement. So if you put your product for the purpose of advertisement before finding design application, you have made the blunder. And for that, not only Pune case, I know 35 applications of very renowned company has been rejected because of the lack of knowledge and awareness that their applications are rejected because of all Amazon publication, Amazon display, Amazon advertisement. So I say that design awareness, particularly to the sector where they are using as tools for.
Okay. Sir, is there any way out so that we can bring such kind of the awareness among the applicants or is the creator of the design protection, my design creator?
We can go for awareness because already government has decided to teach 1 million students, entrepreneurs, startups to aware the intellectual property, not only design, but also in all parameters of design. And also you are well aware that in GEM portal, if you want to put your any product for getting registration, for getting tender from the government organizations, you must create one intellectual property. At least trademark should be taken for your product. Otherwise, you cannot register in GEM portal for getting the tender from any government concerns. So I believe today is the time to aware all the entrepreneurs, irrespective of their size, to aware about intellectual property. Otherwise, they cannot stand in 21st century. So world is very small and everyone is looking your business. What is your flaw? And if there is any flaw in your business or activities, if you don't go for legal advice from the lawyers or from any office or resource persons, then similar type of happenings may happen, which may go against your So this should be created, and I believe this is not the last. This kind of program should be continued whole year, particularly to protect our MSME sectors, because they are very much least aware about these protections. They are putting the product first in the market and coming for registration in design office. How can it be? That's my point.
So this is the unique case that is a wallet, the leather wallet. He has given it, he filed it through some attorney, and the citation is his product only, which is getting back to him. So it's a very sad case.
They are not very much aware.
Yeah.
They are thinking like copyright and trademark. In copyright and trademark, prior use is not the factor for getting registration. So you can go for prior use and thereafter coming for registrations in trademark. In copyright also. They are thinking about copyright trademark. But in case of patent and design, you must follow the new and originality for design and the novelty and inventive state in case of patent.
Sure.
So in these two cases, you must keep in mind publication means Paris and patent and design registration means varies. These two things I just quoted. If you want to flourish your business, first to come and file the application, then go on any activity. I am not telling you that after registration you have to wait. Just after filing, you get the date and go for business. Then you put the product in the. I have told in one company, if you can erase the date in Amazon site from the just date, then it will be not clear for the examiner and controller on which date it has been published.
Okay.
But that person is not willing to remove the date. See, that person is saying, no, I am putting the product from that day, my product is advertised from that day, how can I remove that date? But then you lose your registration.
Sure.
They are so reluctant to remove the date. We have given advice, you just erase the date. You ask Amazon to remove that date, then you will get the registration. They are not willing to remove that.
Oh, okay.
That's my point.
So if they remove that product from Amazon or the Flipkart, so do you, the design office should consider?
Yes. Oh, not the product. I just, our examiner controller saying, you just remove the date on which date you have floated that product on the Amazon site.
Okay.
Then it will be very much, and it will not be sure that the application is filed after or before that date. Then you can get the registration.
Sure.
Yeah, but they are not willing to remove that date. They say, no, I have put that product from that date, I have sold the product, I have the voucher and everything. How can I remove that date? There will be an offense if I want to remove that date and say, I have developed that product after filing this application and put that product. So they have lost the registration. That's right.
Right. Yeah.
Thank you, sir. Thank you so very much for that wonderful interactive session. Now,
Good evening. Good evening, madam.
good evening,
I have
sir.
one question, madam.
Oh, sure, sir. Sure. Please go ahead.
Good evening, sir. It was a really very informative session, sir. I have one question. Can you highlight the case of the patent war, design patent war between Apple and Samsung? And Samsung won the cases in different countries like South Korea and Japan, and USA, Apple won the case in USA. So there is a uniformity of this patent design patent war.
See, one thing I want to very clear you that patent right or design right is your territorial right. Patent right or design right, you don't show any US case or the Europe case or the other countries case. I just say at the time of registration, I need global novelty. But after that, whenever you are getting registration, say for example, Apple didn't take any registration from India. Only they have taken registration in USA, so he has filed the infringement suit there in USA and got the order. But if the similar product is imported here and market Apple without any registration, they won't get any protection of infringement. So if you want infringement benefit, that means the compensation from the infringement from the infringer, then you must show that similar or corresponding product is registered in India under Design Act or the patent. Only then, in that case, Indian court will take up the matter. Not only that, and at that time you have to show that your patent and design is in force also. It has not become seized. It has not become public domain. It has not been cancelled. Then only you can get the benefit of that. Otherwise, understand my point?
Yes, sir. Yes, sir. So means Apple has to register in India as well.
If Apple registered in India, then I have to see from which date he has got the registration and got the monopoly of right, and who are the countries are infringing their product. I have to see the total case. Only by a statement, I cannot decide and say anything about the fate of this case. If it is so that Apple has the valid registration, it is in force, and it is copied by other companies, and it is proved that there is no license agreement or no compulsory license system is there, so in that case, I typically court will decide, and that case will be made to the appropriate jurisdiction, not below district. And if that order is passed by the court against the infringer by way of giving the interim injunction or the permanent injunction or any kind of compensation, then only appeal can get the benefit. Otherwise, if the infringer is going to counterclaim of the product and file the cancellation of designs as well, at that time, court will not decide anything till the disposal of the matter from the design office. Because if it is under dispute or under any problem and sub judice, then at that time I cannot say, or court cannot say that he is a real infringer. Understand my point? No? So a lot of things are
Yes, sir. Thank you.
lot of things are to say.
Sir, I have one more question very briefly. Sir, regarding this design search,
Yes.
so it is a very crucial because I have to find out if I create something a very unique design, and I have to know this whether the particular design is already registered with this design office in India. So I have the only one procedure that I have to apply before the design office that kind of citation, or there is any other system we should follow, the one should follow?
Yes. In Design Act, there is a unique provision of search. So you can have the search report from the controller of design by giving your representations, that is the views of the different views of the articles, or by number. You can ask the search report from the design office whether the application to which you want to file for registration, whether it will be considered as new or original or not. So before that, many companies are coming for doing or conducting search before filing application. But I have some reservation on that, particularly on that point. Why? Because it is, you can go for search, but that search report is not exclusive enough, because that is based on certain available documents, and no search in the world is absolute search.
Yeah.
So if the application after filing refer to the examiner, an examiner can find out certain documents. So in that case, your application may be objected with the citation. So that search report is not the absolute search report, because search is done based on certain available documents.
Yes.
And if the examining examiner during prosecution of the application for registration has got different citations from different websites or different Flipkart or from Amazon, they are very much allowable to give the citations. So in that case, your case may be objected with the citations and the prior publications and not new and original also.
Sure.
So, but there is a provision of search also in the design law, and design office is producing that thing, giving that thing before registration.
Okay. Thank you, sir.
Thank you, sir, for sparing your valuable time and joining our session and giving a very compact and informative session to our participants. And really, the whole session was a very much a thought-provoking one and absolutely covered all the aspects of design. And I am very much hopeful that all our participants have benefited a lot out of your lecture and they have learned all the nitty-gritties and every aspect of Design Act. Thank you very much, sir.
Thank you. Thank you.
Thank you so very much, Dr. Mitro. I thank you on behalf of the Novelty University and the organizing committee for your valuable time and your wonderful presentation. Thank you, sir.
Thank you.
Dr. Mitro, may I request you to please stop presenting your screen?
Yes. I'm going out.
Thank you, sir. Thank you so much. So, Rakesh sir, should we proceed?
Yeah. Our next expert is
Yes. So, after that wonderful session in the first half, we now move towards the second session of the day. We have with us another esteemed speaker, Ms. Lovishka Sizore Bilto. I hope I am pronouncing your name correctly, madam. Lecturer in law at the department. Thank you. Lecturer in law at the Department of Law of the University of Mauritius. Ms. Sizore is presently a lecturer in law at the Department of Law at the University of Mauritius. She is the holder of an LLB honors from the University of Mauritius. She also holds a master's in law from the French University of Aix-Marseille-Cézanne, where she was awarded a diploma as commercial law jurist. Ms. Chizore's research interests are in intellectual property law, commercial law, and civil law. She was a board member of the Law Reform